Imagine dedicating time and thought to creating a document meant to protect your loved ones and articulate your final wishes, only to discover it cannot fulfill its purpose. This can be a deeply unsettling thought, and understanding why such a vital document might fail is key to securing your legacy. Simply put, a last will and testament can be considered invalid if it fails to meet the specific legal requirements of the state where it was created, or if its creation was tainted by issues such as a lack of mental capacity, undue influence, or outright fraud. The primary reason a will might be invalidated often boils down to improper execution. Each state has precise rules about signing and witnessing the document. For instance, most states requiring the will to be signed by the person making it, known as the testator, in the physical presence of at least 2 adult witnesses. These witnesses usually cannot be people who will inherit something from the will, as that could create a conflict of interest and render their testimony biased. If these steps are not followed precisely according to state law, a will can be challenged and potentially deemed invalid. Another significant factor is the testator's mental capacity at the time of signing. For a will to be valid, the testator must have been of sound mind. This means they understood they were signing a will, knew generally what property they owned, and who their closest family members were, even if they chose not to leave them anything. It does not mean they had to be perfectly healthy or without any memory issues, but they must have possessed a basic understanding of their actions and the document's purpose. Beyond execution and capacity, a will can be invalidated due to undue influence or fraud. Undue influence occurs when someone improperly pressures or coerces the testator into making specific provisions that do not reflect their true, independent wishes. Fraud, on the other hand, involves deliberate deception, such as tricking someone into signing a document they believe to be something else, or falsely telling them a family member has passed away to influence their decisions. So, what can you do to ensure your will stand strong and your intentions are honored? The best first step is always to consult with an experienced elder law attorney. They can guide you through the specific requirements of your state and help you draft a document that will hold up under legal scrutiny. Regularly reviewing your will, especially after major life events like a marriage, a divorce, the birth of a child, or significant changes in your assets, is also crucial. This ensures it remains current and accurately reflects your intentions. It is also worth noting that some states recognize what is called a holographic will, which is entirely handwritten and unwitnessed. However, these are often subject to stricter scrutiny and can be easier to challenge in court, making a formally prepared will a much safer and more reliable option. Additionally, some well-drafted wills include a self-proving affidavit, which is a sworn statement signed by the testator and witnesses before a notary public. This document can simplify the probate process by providing official confirmation that all signing formalities were met at the time the will was executed. Ultimately, understanding the potential pitfalls of will invalidity and taking proactive, informed steps ensures that your wishes are honored, your legacy is secure, and your loved ones are spared unnecessary legal burdens and emotional distress during an already difficult time. This careful planning brings genuine peace of mind to everyone involved.